Morning. Please be seated. This is the time set for oral argument in Aubuchon et al. Versus Brock. Our cause number 1CA CV130451. As some of you or all of you may be aware, the court has read the briefs, conferred about the case before coming into oral argument today, so we are prepared with a thorough background of the case, and you may bear that in mind as you begin your presentations. Our argument today is being videotaped, as all of our arguments are, and it will be posted online. So if you do us the courtesy of announcing your name and the party, if any, that you represent before beginning your presentation, we would certainly appreciate that. Each side has 30 minutes total. And I understand that there's been a division of time, a four-way division of time on the appellee's side and a two-way division of time on the appellant's side, which is fine. But in view of the need to watch your own clock, please be cognizant of that and be express about who you represent so that we can keep track of what is an unusually distributed time frame. With that, we may begin.
Thank you. Good morning. May it please the court, my name is Lisa Aubuchon. I'm here on behalf of myself. The other plaintiffs have joined in my argument. We are also joining in Mr. Moriarty's argument, and he will discuss the unconscionable fees that were awarded to the Polsinelli defendants, and under the theory that there's really no legal justification for that. So he will spend his time on that. Plaintiffs are without counsel. In case you are wondering why, the State Bar basically usurped this court's authority and just adopted Judge Duncan's complaint and used that to take away the license of my very kind-hearted and wonderful attorney, despite his stellar reputation. Some of the same people that were involved in this case were involved in that, and basically we've been left without counsel because no one in the state of Arizona could come in and represent us based on the State Bar's findings. I hope that this court will do justice and actually look at the case, the facts, and remand the case and allow the amended complaint to go forward. What happened at the trial court was really a travesty, and that I was treated, as the others were, differently than other litigants. The judge basically ignored the black letter law on a Rule 8 and Rule 12 motion. She basically just jumped to the conclusion that everything in that complaint was frivolous, and that despite the fact that she allowed amended complaint to be filed, she then changed her mind later, even after she said that sanctions would only be awarded if the new complaint did not comply with Rule 11. She basically just changed her whole opinion at that point, and throughout everything is futile. Judge Cooper was actually the judge on the case. And in November, for some reason, Judge Duncan became appointed to the case. There's no explanation in the court record as to why that occurred. And in fact, as the record shows, Sally Duncan was a friend of Gary Donahoe's, and he admitted in a deposition that they had lunch together and talked about the case. We tried to file a motion to have her removed for cause, but the judge basically concluded that because Gary Donahoe wasn't a party, even though a lot of the facts involved Gary Donahoe, that there wasn't a conflict of interest.
But you're not contesting the denial of the change of judge on appeal?
I don't believe that that was included in the notice of appeal. For background, I think it's important to note that she basically ignored the standards under the rule. And again, we are here on a motion to dismiss. We're not here on a summary judgment motion. We're not here on a trial. And I think that's important for the court to note. And I don't want to sound like I'm lecturing the court on the law, but I think it's important to get out the fact that we had an original complaint here that had a lot of facts. And I know there were a lot of facts, and a lot of the counts weren't specifically numbered, but you have to keep in mind a lot of the claims here relate to years of activities that went on, and we thought it was important to bring those out in the complaint. When we filed the amended complaint, it was much shorter. It focused on fewer claims. It focused on fewer defendants. And that was supposed to be allowed by Judge Duncan until she changed her mind.
Did you mean the second amended complaint or the first when you?
Well, I just want to clarify. The second amended complaint was actually, yes, that's what I'm talking about. The first amended complaint was actually filed the day after the first complaint was filed, and it just dealt with some formatting issues. It wasn't a substantive amendment. So the second amended complaint, I apologize, is what we're talking about today.
Can you address, I know you have many claims to discuss and not a lot of time to do it, but can you address why the second amended complaint didn't include claims against the Polsinelli defendants?
Well, there were a lot of reasons, and I know Mr. Moriarty will discuss them. Some of them were the threats that were made. Some of them were the warnings by Judge Duncan that we went back and very, very carefully went through it. We believe that they were valid complaints because despite the Pulcinelli's argument that it was based solely on the reporting to the state bar, that was not the case. If you read through the complaint, there was activity for years with Tom Irvin and Ed Novak regarding representing various complainants, various people in the court system, various actions they took. So he will discuss that a little more detail, but that was pretty much the decision that was made, not that we agreed there was anything frivolous about it to start with. The court must assume the truth of the well-pled factual allegations and indulge in all reasonable inferences therefrom when they are looking at a 12B motion. It's been the long-standing law in Arizona that dismissal of a complaint is disfavored. Dismissal is not appropriate when any state of the facts can conceivably prove what the plaintiff would be entitled to.
Well, that's the pre-Cullen standard. Under Cullen, it's been tightened up a little bit, perhaps not as far as the federal courts did in Twombly.
Correct.
But the any conceivable state of facts, I don't believe is the current standard.
Well, Your Honor, the court is supposed to take all the facts and assume they are true, and if there is any basis for a complaint to basically go forward, the court is supposed to look at that and allow amendment to address any legal issues.
I think that's a fairer statement of the standard, yes.
Thank you. Basically here, that's exactly what we did, and I wanted to go through basically the counts in the second amended complaint to try to show why that was not futile. And I want to start with count 1, which is defamation. Now, this is a textbook claim. There's absolutely nothing missing from this claim. It's clear that Andrew Kanasik wrote a letter to the citizens of Arizona. He published it throughout the state, and he accused Dave Hendershot and I of crimes, of extortion, of bribery. And if you look at the second amended complaint, I just want to read through some of them. He said that we brought a fabricated case to the grand jury, that we knew that things were false and we created them for basically our political ends. He also claimed that we had the most demented minds in law enforcement. He said, unable to obtain an indictment, we opted to smear his name, that the actions were a vile abuse of the duty. He said that we brought charges without any evidence of a crime. And then he proceeded to talk about bribery and extortion. He also said that we would face indictment. And then he went on TV, and despite having the actual tape of the free talk, he told everyone that I had committed extortion and bribery. And he knew that was false because he had the tape, and in fact there's been a subsequent determination that that was not extortion. So again, looking at all these facts and allegations as true, this clearly sets forth a claim for defamation. It also sets forth the claim for intentional infliction of emotional distress because he did it knowingly. He went out, he intended to destroy us, he intended to basically cause us emotional distress, and that was pled that it was, in fact, suffered. So there's nothing, again, missing from that claim. On count 3, that deals with Dave Hendershot, and although I'm not allowed to appear to represent him, I just want to say that because the whole complaint was thrown out as frivolous, that those claims were also viable. Counts 4 through 6 dealt with contract claims, and that had to do with my employment as a deputy county attorney. And there is no doubt that the complaint set forth facts that I had a contract of employment and that any policies and procedures can be determined by a jury based on Lindsay versus University of Arizona and Wagonseller versus Scottsdale Memorial Hospital, that those oral representations can modify an employment contract. There had been a history, for example, of every attorney that had been accused of any kind of bar violation of having their attorney's fees paid. That had been done in every single case. I was assured of that, and that was not done in this case. My attorney was fired.
I'm sorry. How were you assured of that?
Verbally and in writing.
When were you assured of that?
Throughout the 10 or 14 years that I was there.
So as this issue may have come up, they would reinforce for you the fact that if you were ever in this position, they'd pay your attorney's fees as well, or how was it stated to you?
Absolutely. I was actually division chief. I oversaw 120 employees. I had 50 attorneys. I had attorneys that were accused of bar complaints, through bar complaints throughout. I was told specifically that the office would pay for their representation. The office would assist in defending them. I was told that repeatedly through my employees and myself as well. And as part of management and the policies and procedures, I was aware of that. And we even taught that in training, and I oversaw training. I also note that in terms of the breach of contract for employment, there's probably a concern that there was a merit hearing proceeding. But I think this is a little bit a different situation, because that merit proceeding had to do with alleged violations of policy and procedure by the new county attorney. And it did not look at the actual contract of when I worked for Andrew Thomas and everything that was approved by him under the contract.
But I believe in the briefs you've disclaimed an attempt to appeal any claim based upon the termination of employment, and focused instead on the representations concerning payment of fees that you mentioned earlier.
Basically, the representation of fees and that as well. But I think it's important to note that in this merit proceeding, contrary to that contract, they basically ignored the fact that Andrew Thomas had approved all the actions that I took. And again, they went forward on that. They then took away my attorney. They fired my attorney. I actually had a letter appointing an attorney, and that was brought out in the complaint. They fired him, and then they refused to appoint counsel. They also refused to provide me information that was exculpatory to me for the bar matter and for the merit hearing. Subpoenas were quashed, they were ignored, they were denied. In fact, in the middle of the bar hearing, there were emails produced, just magically. So there were a lot of things that were breached in terms of that contract, and I think, again, that is a clear claim that can't be disputed. A jury can determine what the terms of that contract was, and that should be remanded. The breach of covenant of fair dealing also dealt with the refusal to pay for the attorney's fees despite the promises, and the interference of contract when they basically fired my attorney that was already contracted for. I'm really short on time. I just wanted to go through and note to this court that, again, the second amended complaint tried to be very specific in terms of the claims, and I think the judge basically treated this like either a trial or a summary judgment and did not look at their true standard under Rule 12. Thank you.
Thank you very much.
May it please the court, Your Honor. My name is Ed Moriarty. I am appearing here today pro se, as shown in the writings. A couple of matters, very quick, based upon questions. Asked if we were appealing the failure to recuse Judge Duncan. We have not, because there's so many other things. It's not that we approve of it. It's all part and parcel.
It's not an issue before us today.
Pardon me?
It's not an issue before us today.
That's correct,
okay.
Your Honor, and that's the thing. And in reference to the standard and the case that Your Honor, Judge Swan cited on any conceivable facts, to make a judgment as to whether or not the facts are conceivable, one has to look at them. And the record shows that Judge Duncan accepted all of the facts in the second amended complaint. And she said she was going to treat them as true. And then she threw out the entire, or she didn't grant our motion to amend and put in the second amended complaint. So, as counsel has said.
But you would agree that the standard isn't any conceivable facts, but rather, assuming we take all well-pleaded allegations as true, if a claim could be established, then the claim should proceed.
Yes, we have no problem with that, Your Honor, and that's what I was trying to clarify. And as Ms. Aubuchon has said, the brief and her arguments support all of that. And the third thing, dealing with the office, the county attorney's office paying these fees, everyone that we have ever seen, and it's noted in the record, it's never been contested. That is the standard, that the county pays for that. It was stopped by the Board of Supervisors and the interim county attorney, as Ms. Aubuchon has said. Now, Your Honor, question was asked as to why the Poncinelli I'm dyslexic, and I apologize. I'm not intentionally mispronouncing things.
I understand what you're saying.
Okay, thank you very much, Your Honor, because I want to make sure that you don't think I'm being disrespectful. Thank you. There was some question based upon the filings that were made to the original complaint and the first amended complaint as to whether or not we were making a claim of legal malpractice against the Poncinelli law firm and Mr. Irvin and Mr. Novak. We were not. We explained it to them at that time, and then on January 20th, 2012, when Judge Duncan had her initial hearing, we explained that, and there was quite a bit of discussion about it, but that was explained in the transcript, page 9, line 2, and following that. So, go ahead.
Well,
no, I don't mean
regardless of the merits of a malpractice claim, which weren't asserted in the second amended complaint.
That's
correct. I'm curious then, as we evaluate the trial judge's exercise of discretion in imposing sanctions, how would you explain the fact that there was a claim that needed to be defended, and then that claim disappeared without adjudication?
That's the point. There was never a claim. There was never a claim for legal malpractice.
Well, but there was a claim. I mean, the Poncinelli defendants were in the caption.
They were in the caption in the first complaint for their acts and omissions in reference to what they did that led to the first complaint. There's a whole series of them in the facts in the brief that shows examples. We said that there was a conflict that the Poncinelli and Mr. Irvin had.
Were you seeking a judgment against the Poncinelli defendants?
No.
No.
Oh, in the first amended complaint, first amended complaint, yes, we were.
You were seeking a judgment.
But not as our lawyers, not for legal malpractice, Your Honor.
But you had asserted claims against them.
Yes, we had. And then, as explained in the brief, we had made the determination that trying to fight that battle, and call it a debate, was not going to move the case along. So that is why we withdrew anything that appeared under any circumstances to be an allegation of legal malpractice against them. Their same acts and omissions, the conflicts representing the Board of Supervisors, representing the Superior Court of Maricopa County, representing in all of these actions and that we have listed in the facts.
Sounds an awful lot like malpractice.
Well, except, Your Honor, under malpractice, you can only sue your lawyer for malpractice.
I'm not saying who you can sue. I'm saying the basis of the claim. It sounds to me like you're asserting the essence of malpractice without saying it.
No, we were asserting that what the Board of Supervisors was doing and why they were doing it. And they were doing it as in part on reliance on legal counsel, and we were attacking on those grounds, Your Honor.
I guess the concern, though, is at one point Poncinelli is the target of a request for judgment, right? You sue them, you want a judgment against them, and then by the time we get to the second complaint, they're simply gone. If the trial court took that as a concession that the original claims lacked merit, I assume you would say the trial court was wrong, but I'm curious as to why.
We said that the trial court was wrong in our brief, but
why? I mean, if anytime a court sees a claim disappear without settlement, it wonders if the claim was improvidently brought. So, what would your rejoinder to the Superior Court's reasoning be?
We explained, I thought, in the brief, but in response, they were so deeply involved in this that their actions, not as our lawyers, but their actions and the information that they gave to the Board of Supervisors. For example, just look at Doughton. They were the attorneys involved in that. They were the ones that gave all of that information. This is history that occurred long before Ed Moriarty even knew that this incident was going on or taking place. It goes from 2006 to through 2012, and it's tried to be put in order and explains all of that.
Okay, thank you.
And, okay. I haven't gotten to the things that I was going to talk about, but in that regard, Your Honors,
Have some time.
Huh?
You still have some time.
Yeah, but thank you. We have listed the reasons why the sanctions that were awarded in excess of $200,000, and against Polsinelli is $185,000 plus some costs. But the bottom line is this: they billed to justify these attorney's fees. When they supplied those documentation, we asked for an evidentiary hearing. We asked for them to be required to put the proof up. The court did not permit us to do that. We were never permitted to cross-examine one single bit about this in reference how they justify $200,000. And that sanction had to have come after the January 20th hearing where we got permission to file a motion for a second amended complaint. They weren't even in the case. The case law that we cite goes through that the awarding of these were absolutely unreasonable. They were out of the case. They failed to mitigate. They failed to do anything about it, but they simply sent billings. They gave billings for a lot of work done during the disciplinary hearing, all kinds of things that didn't have any relevancy whatsoever, as explained in the brief, Your Honor.
Okay.
And the case law as to why. And in reference to Judge Duncan said on the January 20th in the transcript that I am giving you due process warnings, and any further action, and she said specifically any further action, I will, if I find that further action improper, award sanctions. In part, that's why we removed them from the complaint, Your Honor, just out of fear. If you want a straight answer to that, which you do, and for the legal reasons too. But the fact is, nothing occurred after she gave us those warnings. We had dismissed them with the second amended complaint within the 21 days in the safe harbor dealing with Rule 11. And the same with 12-249. Totally unreasonable, Your Honor. Not necessary. And thank you very much.
Oh, thank you.
Good morning, Your Honors. My name is Jim Armstrong. I'm with the firm of Sachs Tierney, and we represent the Applee Maricopa County in this case. I don't want to go through all of the issues raised in the opening, but I think there are a couple of points that should be mentioned. First, Ms. Aubuchon indicated that her belief that the Supreme Court usurped its authority in disbarring Mr. Moriarty by simply adopting Judge Duncan's rulings, seemingly as part of this whole overall conspiracy against them in this case, including Judge Duncan magically appearing in the case at some point. I just want to make it clear on the record that what actually happened is Mr. Moriarty consented to the disbarment, and that was the basis for it. I also want to point out, my goal here is to kind of really focus on what the true issue is in this case, what the applicable standards of review require, and also to point out the numerous waivers that have occurred in the briefing of this matter. First, we are not here on a motion to dismiss. What we are here on is the denial of a motion to amend, and the reason that's important is two differing standards of review.
Doesn't Cullen apply to the futility standard?
Excuse me?
Doesn't Cullen apply to the futility standard?
It applies to part of the futility standard. We think there are two parts to that. It does apply to the 12b6 aspect of it. It doesn't apply to the Rule 8 part of the futility standard, which is something I wanted to emphasize as well, is that Judge Duncan really gave three independent reasons for denying the motion for leave to amend, two of them governed by the abuse of discretion standard, one by the de novo standard under 12b6. The first of those three reasons was Rule 7.1. This is an issue that came up repeatedly in the trial court. Rule 7.1a requires all motions to be supported by a memorandum of points and authorities with specific reference to the supporting legal authorities and arguments. There's no dispute that that was not done here.
That would be a thin basis, though, if that were the only basis on which to deny the amendment, given the discussions that the parties had had with the court beforehand about the contemplated amendment, right?
Well, in ordinary circumstances, I would agree with you, Your Honor, but there was a difference here, and as Judge Duncan repeated on three occasions in her rulings, she found that the plaintiff's motion for leave to amend fails to comply with Rule 7.1a and b, and she says specifically, and I want to make specific note of the fact that this is not the first violation of the rules of civil procedure. So it was part of the overall noncompliance that I think supports the Rule 7.1 ruling.
But you're not suggesting any party was surprised by the motion to amend?
No, I'm not,
for a
Your
second
Honor.
amendment complaint. I mean, what's the purpose of Rule 7.1? Would it be to put other parties on notice that this is coming, and here's the justification for why we need to amend, and thereby gain approval? But the court had already said, go ahead and file it.
The court said, yes, go ahead and file your motion, not file your amended complaint.
The motion. Yeah.
Correct. And as
So
far
I guess I don't really contemplate what would have been in a memorandum other than saying, Your Honor already authorized this in such and such hearing. We are hereby filing this, requesting authorization to move forward.
Well, under Rule 15, there are grounds for amendments of complaints. Is there prejudice to the other side? Does the amendment cure the defects from the prior complaint? Various standards that have to be met, and I think that's what Rule 7.1. I don't want to dwell and spend all my time on Rule 7.1, but I think it is an independent reason, and we do not believe Judge Duncan abused her discretion by relying upon that rule as an alternate basis for denying the motion for leave to amend. The second ground is Rule 8. I'm not going to reiterate everything in our brief, but clearly what's important to remember is that the appellants have not challenged the defects that were pointed out in their first amended complaint. They made no efforts to say this was a viable complaint, either in the trial court or on appeal.
This is an appeal from the second amended complaints.
Correct. And what I want to say about that is, if you look at under Rule 15, you're required to submit a red-lined version of your proposed second amended complaint, which they did. And I think it's astonishing if you look at it carefully. What they simply did was just cross out paragraph after paragraph with seemingly no rhyme or reason of their original complaint, making it even more incoherent than it was to begin with. So we think, again, this is part of the futility rationale, is they did not cure the Rule 8 problems in the second amended complaint. It still was incoherent. It reads like a bad crime novel. It doesn't link.
If you read the version without the red line, it's a lot more coherent. Sometimes massive revisions can make for poor red lines, but it's a lot more readable than the first amended complaint, right?
I would disagree with you, Your Honor. I think it's actually worse because of some of the gaps that are left by those missing paragraphs. But again, the point is that the ANSERV case, which we cited on the Rule 8 standards, cites a Ninth Circuit decision, McHenry, and gives it great weight. And there are 2 points about McHenry that I wanted to bring out too. First of all, that a dismissal under Rule 8 is subject to an abuse of discretion standard. There's no Arizona case law on that, but there's several federal court decisions that we cited, including McHenry, that provide that standard of review. The second point I want to make too is in McHenry, the court says that it's not necessary for a complaint to be entirely without merit to be dismissible in its entirety under Rule 8. And because the good claims, if there are any, are suffer just as much as the bad claims if there are problems under Rule 8.
Given the limited time we have now, I'd like to have you focus on the substance of some of the claims rather than the draftsmanship issues.
Okay.
And given the limited time you have now, why don't we turn to the breach of contract claim?
Okay, that's right in my notes. First of all, there was no breach of contract claim against Maricopa County. If you look at it, and I don't recall offhand, but the breach of contract claim I think was made against Mr. Montgomery and 2 other individual defendants. Maricopa County is not named on the breach of contract claim. It's not named on the breach of the covenant of good faith and fair dealing.
No, but it's named in the caption and the allegations are there. I think under Cullen, you might be slicing it a little thin to say that they have to be named in the heading for each complaint. That the county is a defendant in the case and its agents are being sued under breach of contract theories. So what element of a breach of contract case was not satisfied by the allegations of the Second Amended complaint?
Well, again, I think I would disagree with you, Your Honor. That's part of the reason under Rule 8 is that you set out, and Rule 10 requires specific paragraphs setting forth the claims against which defendants. And I think it's fair for a defendant to rely upon the claims in which it is specifically named. And the one that involves the county is the inducement, the tortious interference with, again, Ms. Obashan's claim that she had a contract to be reimbursed for her attorney's fees.
That's actually the breach claim. So if assuming for a moment that you get past the headings, if there is a breach of contract claim alleging that there was this term of the employment contract, and I'm not saying there was or wasn't, but if that allegation is made and the allegation further is that county failed to make the payments it promised to make, why isn't that, at least in theory, a viable breach of contract claim?
In theory, it may very well be, Your Honor. And if this case is remanded based on that sole ground, I can tell you that despite, and again, I'm going off the record here, but again, the theory here, I can tell you the Maricopa County Attorney's Office has a written policy on the reimbursement of claims in this very situation.
I want to take your time up with
Okay.
future speculation about a record I don't have. So.
Well, again, I think you have to rely, I mean, the plaintiff is the master of their own complaint, and I've only got 45 seconds, so I'll go very fast on this. And I think we have a right to rely upon what claim was actually pled against the county. The only one was inducement. The inducement claim, we pointed out that you cannot, a person cannot interfere with their own contract, which is the logic of their claim. And they have failed to respond to that argument anywhere. It's one of the many instances of waiver that we've detailed in our complaint. Unless Your Honors have any more questions, I turn it over to, I think, Ms. Orsi.
Very well, thank you.
Thank you.
For the record, I'm going to jump in next. My name is Mike Frizzell, and I represent Supervisor Kanosic, former Supervisors Brock, Stapley, Wilcox, and Wilson, the former County Manager David Smith, Assistant County Manager Sandy Wilson, former Interim County Attorney Richard Romley, and former Deputy County Attorney Paul Ayler. And the reason that we think that the trial court has got this right, to speak in broad brushstrokes, is that there's too much of a burden placed upon the litigants and the court when attempting to deal with a pleading that is written like this one is. To this day, some of us, myself included, and I will admit on the record I'm not as bright as most of the people in this room, still don't understand parts of what they're getting at here because they're not written well in the first place. I'm still representing people, for instance, to use extreme examples because I've got limited time and need to be extreme. I'm representing a former supervisor by the name of Fulton Brock who doesn't have a clue what is in these pages and pages and paragraphs that has to do with him, other than being in the caption and being told in some of these counts and the headings to the counts that they apply to all defendants. Same thing with former Supervisor Wilcox, same thing with former Supervisor Stapley. There's these pages and pages that start out this pleading, and they do make some references to some of my clients. With respect to some of them, they don't make any references at all. Then you jump to the counts, and you realize, well, some of my clients, at least by name, somehow got left behind. So what kind of notice is that? What kind of disclosure statement do my clients file if we got to the point where we had to draft an answer and then deal with that within 40 days under the rules, et cetera, et cetera? Those are the problems. That's why my clients don't believe it was an abuse of discretion by this trial court to refuse the filing of this second amended complaint. It did not cure the defects that were present in the original complaint or the first amended complaint. In many respects, just by way of example, some of the ones that I've just mentioned. And a pleading is supposed to give folks notice as to what they're supposed to defend. And with respect to a great many of my clients, that simply has not happened here. And as a result, we're very comfortable with the trial court's rulings and hope that you will find the same after contemplation. Thank you all.
Thank you.
May it please the court, I'm Victoria Orsi. I represent the current county attorney, William Montgomery, and Mark Fall. It's our understanding that Mr. Fall, having been dismissed in the first complaint, is no longer a part of this, so we don't need to address his participation. We're hoping that the judgment is final as to him. With respect to Mr. Montgomery, the record before the court is clear that there is no dispute that the allegations of breach of contract or inducement of contract or bad faith covenant, breach of the covenant of bad faith, good faith and fair dealing that have been asserted by the plaintiff were based upon a contract that my client, Mr. Montgomery, had no part of, no participation in. He is not alleged to have had any contract with Ms. Aubuchon. He could not have had any contract with her, even as an agent of the Maricopa County Attorney's Office, because he took office, and it's admitted in the record that this is true, and it's a matter of public knowledge that the court can take judicial notice of. It's in the record that Mr. Montgomery took office as the elected county attorney after Ms. Aubuchon was terminated from her employment with the Maricopa County Attorney's Office. He therefore, he's not alleged to have had a contract with her, and he's not alleged to have actually breached any portion of that contract, or any specific portion. The only factual allegation against Mr. Montgomery, if you cull through and set aside the conclusory allegations and the conclusory legal claims being made against him, if you set all of those aside and you try to find a factual allegation against my client that is used as the sole basis for the multitude of claims that are still asserted against him in the proposed second amended complaint, you will see that he is alleged to have gotten a letter from the plaintiff's counsel, presumably in the bar case, and he did not respond to that. So that's the full factual allegation, if you parse out the rest of it, against Mr. Montgomery. He cannot possibly be responsible for a breach of contract. There's no factual allegation that he induced a breach of contract or that he continued any breach of contract or any other tortious acts against the plaintiffs. There's no claims against my client by Mr. Hendershot whatsoever in the first amended complaint or the second amended complaint. And we are dealing with a second amended complaint. So if this matter gets remanded in any form, there's not a third bite at the apple. The plaintiffs aren't asking for that. They're asking you to send this second amended complaint back. If you look at the second amended complaint with respect to the allegations and the legal claims made against Montgomery, it's clear that they are futile. So what happened is that the trial court gave the plaintiffs ample warning, ample notice, ample focus on the rules. You need to move to amend. You can't just file an amended complaint. You need to fix and address the Rule 11 defects. You need to address the Rule 12b-6 problems. And so this court asked the plaintiffs with respect to the Polsinelli, what happened to the claim? Can't you just concede that it disappeared? It must not have been viable. And the plaintiffs were reluctant to concede that. I understand why. But for this panel, I guess the question is it worse to just drop off a claim that was improvidently pled, in your words, or is it worse to go ahead and replead the claim with some things stricken out and include improvidently pled claims against people that should not be in there? So unless you have questions about the specific legal claims that are being made against Mr. Montgomery, I would suggest that a reading of the record makes it clear that there are no viable claims asserted against him whatsoever.
I have one question for you. Your big issue is timing, right, as to when Mr. Montgomery came onto the scene and what had already occurred by that time?
Well, that's the best issue, and that is a big issue, yes.
Ms. Aubuchon started her argument, or didn't start her argument, but in the course of her argument, she argued that the interference with contract was that the defendants had interfered with her contract with her attorney, Mr. Moriarty. Would timing allow for an argument that he had tortiously interfered with that relationship?
Well, the question is really, is the contract then with the county attorney or with the county? There's not pled to be a contract with the county. Is Mr. Montgomery a third party to the contract? Even setting aside the legal claim and the elements of it, conceivably, yes, and that's not the standard.
But was Mr. Montgomery the county attorney at the time that the decision to terminate Mr. Moriarty's services for Ms. Aubuchon was made?
There's nothing in the record about when that decision was made or who it was made by. And we are stuck with the allegations that are in the record. There's no allegation that Mr. Montgomery did anything other than not respond to a letter. There's no allegation that he was required to do something. In fact, the recitation that Ms. Aubuchon gave to the court about how she was told over and over in policies and in writing that she would be entitled to this, or that other county attorneys were entitled to a defense, that's not pled. None of those factual allegations are in the second amended complaint. And there are no factual allegations that Mr. Montgomery did anything to interfere with that contractual right if she had it.
Okay. Thank you.
Any other questions?
No, thank you.
We submit that, especially with respect to Mr. Montgomery, the trial court's decisions need to be affirmed.
Thank you very much.
May it please the court, my name is Andy Jacob. I represent the Polsinelli defendant appellees. I think it's pretty clear that even though the appellants to this day suggest they had valid claims against my clients, they're not asking this court on appeal to send back to the trial court any of the
I think the sole
claims that
scope
they
of the
made.
issue before us is the sanctions awarded in favor of Polsinelli, and quite frankly, the way I see the issues that you probably should address today are, number one, were the sanctions excessive, and number two, was Polsinelli able to receive an award of attorney's fees given that it had represented itself to that end. I assume that you're familiar with the Munger-Chadwick case and are prepared to address it.
Yes, Your Honor. Let me address that issue first. The Munger-Chadwick case, the Hunt case, those cases are all talking about applying fee-shifting statutes and fee-shifting contract rights in favor of an attorney or a law firm. We're not talking about a contract right to fee-shifting here. We're talking about a sanction that is measured by the value of the time that was expended to defend the claim. We talk about attorney fees. We talk about awarding attorney fees in this case, but it sort of confuses the issue. The judge applied Section 12349 and imposed sanctions, and there are many ways that you can measure sanctions. The goal is to deter the offending party from the conduct, but the amount of the sanction can rationally be measured by the fees that were incurred defending against an improperly filed lawsuit. That's what occurred here. The case law that says there be unjust enrichment or a windfall to an attorney who gets awarded fees when they didn't actually have to pay for the services doesn't apply, because we're not looking to make someone whole, which we do with fee shifting. We're looking to deter the other side.
What do we have in the record to suggest that the trial court employed the analysis you're suggesting it should have, as opposed to a fee-shifting analysis?
We have the ruling from the trial court, which is quoted at length on page 12 of our brief, which starts out at the top of the page. The court has reviewed and reviewed the application for fees pursuant to Section 12349. Now, the trial court did not address the case law on can you award fees that a law firm incurs defending itself, because that issue was not raised until they made a motion for reconsideration that wasn't in the order that the trial court first gave. They could have made that argument before the reconsideration.
But assuming we don't decide the case based on waiver, what's your argument on the merits of that issue?
The merits are that even if we accept the second, that the Court of Appeals decided the case right, that a law firm can't get fees for its in-house counsel when any other corporation can. Even if we say that's right, that case law applies to fee shifting, and it's based on the idea that one party shouldn't be able to get fees and the other party can't. Those cases did not involve fault. They just involve which party prevailed on the case and do they get fees. This is a sanction case. There's fault. The fault is no less because the party that was on the other side is a law firm. The need to sanction the party is no less because the party on the other side is a law firm. It doesn't make sense to allow a party to engage in sanctionable conduct just because it's against a law firm.
And would it then, if that were to be the rule, would it then make it so that Rule 11 sanctions were unavailable in a lawsuit brought against a law firm? It could be as frivolous as you could possibly imagine, but unavailable because it would result in a sanction being paid to a law firm.
It would make it that you would have to measure the sanction in some way other than the value of the attorney time that was put in to respond to the Rule 11 case. And that's how we commonly measure it.
There are a lot of attorneys in this room. Give me a way. Give me a way. It's not based on your hours and your fees. Give me a way that you could impose that sanction without attaching it to the fees.
You would have to turn around and just look at the person and pick some number out of the air and say, this is how much you have to be sanctioned to not do this. It doesn't make sense.
Thank you. Can you address for us that the distinction issue of the much time has been spent on the notion that the judge promised that there wouldn't be any sanctions attaching to the conduct of to the complaint and the first amended complaint, and therefore there was a line in the sand drawn, and everything that followed after that should have been free of any taint?
I'm always troubled when someone says that a judge said something, but they don't quote the language that shows it. The judge did not say you have not engaged in sanctionable conduct now, but you're close, don't do it. What the judge said was, first off, there was a motion that was pending for sanctions, and the judge did not rule on it. That motion was still there. On the issue of filing a second amended complaint, the judge merely said, and I seem to need to remind you, we have rules and statutes that you can violate, so don't do it. It doesn't mean that you haven't done it yet. There's all this talk about safe harbor. Under the Arizona rule, there isn't a safe harbor. And in any case, this was not a Rule 11 sanction. This was a Section 12349 sanction. You violate 12349 when you file an action for an improper purpose.
Rule
That's
11
what they
wasn't
did.
applied here?
We asked for it, but the judge did not grant sanctions under Rule 11.
Okay, and so what's the measure of sanctions under 12349? It's double damages up to $5,000, right?
For damages.
For damages and attorney's fees, yes?
Attorney's fees.
So if the sanction is under 12349 and not under Rule 11, does your attempt to distinguish Munger-Chadwick still hold sway?
Yes, it does, because under Munger-Chadwick, they're not sanctioning. They're trying to make a party whole, and they're saying there isn't a hole to fill with fees because you didn't have to pay any fees out. In this case, we're trying to sanction a party for conduct, and if we say there's a certain class of party who you can violate 12349 against and not be sanctioned, that's not what Munger-Chadwick says.
But your view of this case is that the sanctions to which your firm is entitled fall solely within the authority of 12349 by virtue of the trial court's ruling?
I don't think even the word entitled is right. The sanctions that needed to be imposed to deter the activity is measured by
sanctions
the
that you're
fees.
trying to defend.
Yes.
Are imposed under 12349 and not Rule 11. Am I understanding you correctly?
That's what the court did.
Okay. Do you want to address the reasonableness of the amount in a brief time you have left? Fact is, this claim didn't go very far, and the firm racked up quite a significant.
The claim didn't go very far, but the court has heard the way the arguments get presented in this case. You don't have a stationary target. The complaint was lengthy. We were not dismissed when they filed a motion for leave to file the second amended complaint. There arguably could be an issue. We were still in it. They just left our name off the caption. We could not just walk away from the case like we could if they had expressly dismissed us under Rule 41. The amount of money at risk here, the claim against us was huge, and if you look at how much time was put in trying to figure out what this was and all the aspects of it, the amount of time we put in to defend against this claim was a fraction of what was claimed against us.
Okay, thank you. We're out of time.
Thank you.
Thank you very much.
I want to address just a few things on rebuttal. Excuse me. I'm looking at the transcript from January 20th, 2012, page 14. The court, I said he could amend the complaint. It needs to be in compliance with the rules, including Rule 11. So that's part of the problem here is the court specifically allowed an amended complaint, and then when it was filed, she wouldn't accept it and then dismissed the case. Ms. Orsi talked about the fact that the complaint didn't make any allegations that the policies and procedures and representations had been made regarding the breach of contract and the attorney's fees. I'm looking at the complaint right now, specifically paragraph 156. Aubuchon relied on the material, representation, written policies, and procedures, practice, and assurances throughout her employment that compliance with the policies and procedures of the office would allow her continued employment and would cover any attorney's fees and costs to defend her in the disciplinary action. That's right there in the complaint, contrary to her statement, Your Honor.
When did your termination occur in regard to Mr. Montgomery's arrival on the scene?
It did, excuse me, it occurred prior to his arrival, but then there was a whole merit proceeding in which during that time Mr. Montgomery was present, so there was the appeal process. But I want to make it clear, I specifically asked Mr. Montgomery, as the new county attorney, to appoint me an attorney. What else was I supposed to do? I couldn't go ask Mr. Romley or Mr. Thomas. They were no longer the county attorney. He was the county attorney. I asked for an attorney. He refused to respond. They tried to negotiate with another attorney. They wouldn't agree to pay the fees that he wanted. They wouldn't agree to do anything if Mr. Moriarty helped at all. And there was a letter to that effect we talked about in that complaint. But Mr. Montgomery specifically refused to appoint me an attorney, and that's the basis of that claim. In terms of the fees to Polsinelli, I think that's pretty much been covered. The case law is clear that they are not entitled to attorney's fees by representing themselves. And this case is the reason why, $185,000 to respond to a motion to dismiss. What the parties want is it both ways. They want to say that the first complaint had way too many details and it read like some novel. Well, I'm sorry, but that was really what happened. Those were the facts. And then when we amend it to take them out, then they want to say there's not enough facts to put us on notice. So I think there was a good faith basis on the second amended complaint, once you take out all the redlining and everything, to make it clear what claims were going forward and why. Let's see. And Mr. Moriarty is going to address the rest of those issues, unless you have any questions.
Thank you.
All right, thank you.
Thank you very much, Your Honors. I'll try to be quick. The no right to receive legal fees has been adequately addressed. If you're representing yourself, has been adequately addressed in the brief, and I won't rehash that. The first counsel that stood up said that I consented to the disbarment. Not absolutely correct, Your Honor. There's a hearing next week in the bar dealing with that. It's an ongoing matter, and if they're making representations, that consent did not resolve the disbarment. And now another allegation was made that I filed this complaint against Irvin Novak and Polsinelli firm because I was retaliating because they had filed a bar complaint against me. That is not true. This complaint, the original complaint, was filed on August 11, 2011. As best as I understand, they filed the bar complaint against me in March or April of 2012. I did not even know about the bar complaint until after Thanksgiving of 2012, when the bar gave me a copy of their 235-page complaint against me. It has a whole history that we tried to explain with Judge Duncan, Mr. Book, in the May 4th, 2012 hearing. And Judge Duncan said, I don't want to hear that. I will not listen to that. But the fact of the matter is, Your Honors, Novak and Irvin filed the complaint, along with others, against Aubuchon and Thomas. That was a 535-page complaint. Many of the paragraphs from that 535-page complaint that was filed in 2010, early 2010, or maybe late 2009, I didn't have anything at all to do with any of these. I never knew any of the parties. I was not involved in it. But for me to be then in my bar complaint included in the 235 pages, which were many of the same complaints, that I was at that time still a Montana attorney, which I've been accused of many times. But now, in reference to Montgomery, paragraph 41 and paragraph 77 sets up Romney. The situation with Mr. Montgomery, he wrote a letter to Ms. Aubuchon on April 1st, had another letter on April 4th, and I wrote back to him on April 8th. And I only got into this case because I went to the hearing or the management conference in March of 2011, at which time Judge O'Neill announced that all of the people the bar complaint had been filed against were in default and only gave them a few days. And Ms. Aubuchon did not have an attorney, and I volunteered to do it for nothing, and I put that in the letter of April 8th. Very quickly, Your Honors, $200,000 and some of sanctions has been against me. In order for me to even prepare or come to this thing, I have got on deposit in their trust account $200,000 that I had to borrow. And the reason that I bring that out is this was all of the things that they had been told, denial of second amended complaint and all of the things that resulted from it. There was no animosity. I didn't know who anybody was. I just did it based upon the facts that I've set forth in the brief. And thank you very much for the honor of appearing before you, Your Honors.
All right. Thank you to all for the arguments. The matter is now under advisement. We will issue a written decision in due course, and the court stands adjourned.